Our board of directors requested that our association attorney be here tonight to state his legal opinions, on several issues that the board will present, some of which we'll act on tonight. Mr. Kay's, please do it. Please, take your seat.
You want to sit with me, Tom? Yes. Okay. Much better.
The board, Mr. Kay will present his opinions on several issues, some of which are not on the board, but will be on the agenda tonight, but will come in probably in the next 2 weeks on the agenda. On the first item that Mr. Kay is going to talk about is the board's authority to remove a board member with or without cause whom the board previously appointed or elected to fill a vacancy. According to Florida laws, a board member who has been appointed to fill a vacancy on the board by the board of directors can be just as easily removed from the board with or without cause by the board of directors. When a board member is elected by the membership of the association, then the only way that member could be removed would be by a membership recall. The board members do not choose to remove Mr. Dove Wolf for cause, although each board member has his or her own reason for Mr. Dove Wolf's removal from the board. Mr. Kay, your opinion, please, on this matter.
Thank you, and good evening, everybody. The issue that is presented is based upon a change to Florida statutes that was adopted last year in the not-for-profit corporate section, chapter 617, section .0808, was amended to add the provision that was paraphrased by Mr. Samuels, that individual board members who are appointed by the board to their seats on the board may be removed by the board alone without a vote of the membership. And individuals who were elected to the board would then therefore be only removed through the recall process. This provision of the statute went into effect last year. There was no provision that indicated that it did not apply to condominium associations. There happens to be a bill pending this year that does provide for that particular exception, but until it becomes law, that provision is available to the association at this time.
Okay, thank you, Robert. The second, we'll move on to the next matter. Mr. Kay is going to define the association's right to implement the higher minimum income requirements on sales and lease applications that were previously approved by a membership amendment change. You will recall that the minimum income requirement was $25,000, but was raised by amendment change to $30,000, $35,000, $40,000, and $45,000. The Katzman Garfinkel Rosenbaum firm attorney Mary Ann Chandler, or Donna Berger, stated that this increase by amendment was in violation of Chapter 718, 110.13, and advised the prior board to revert to the $25,000 level to avoid violating the law. This was reviewed by the K. Bender law firm, who gave us a completely different opinion. Mr. Kay?
Thank you. The issue in the statute relative to amendment changes in 718, 110, subsection 13 provides that if an amendment is going to restrict an owner's right to rent their unit, then it only applies to those units that voted in favor of the amendment and those who acquire title to the unit after the amendment was adopted. It's my understanding that the reason for the opinion at the time of the amendment was there was not a clear identification among the records as to which of the units voted in favor and which did not, and that created the issue. However, in reviewing the amendment that was adopted, in our opinion, creating qualification standards for sales and leasing does not fall into the category of restricting an owner's right to rent, and particularly for the reasons that were contemplated in the adoption of the statute. The statute was adopted as a reaction to a decision of the Florida Supreme Court in 2002 in the case of Woodside Village versus Jaron. In that case, an owner had challenged its association's adoption of amendments to restrict renting, claiming it violated his vested ownership rights in his unit retroactively. The Supreme Court of Florida said that in condominiums, when you purchase a unit, that the documents contain a provision that allows for amendment, then you take subject to your rights being amended, and that there was no protected rights of that unit owner to continue renting when the amendment restricted it. So it was allowable under the law according to that case. The legislature, following that, in the year or two afterwards, adopted this provision in 718.110 subsection 13, and the target of that legislation was situations where associations are prohibiting renting, restricting the number of times a year you could rent, limiting situations of that nature. And in fact, there is pending legislation currently that should be adopted before the end of this month, effective July 1. We expect that it clarifies this provision exactly that way and identifies the specific restrictions that were intended to be applied in that provision of the statute. Based upon all of that, it is our opinion that the amendment that was adopted in 2008 is not a restriction on the right to rent, but just an alteration in the qualification requirements for individuals to purchase and lease within this particular condominium. Every unit owner retains the same right to rent that they had prior to the adoption of the amendment, and that the board has the ability to follow those amended provisions without restriction as to any of the units.
In the next 2 weeks, the board will take up that issue and probably raise the minimum income requirement for sales and leases. Right now it's at $25,000, but it will probably revert to that former amendment, but the board will have to restate that at another meeting, probably in 10 days. Okay, now the next item we asked Mr. Kay to address was that the association cannot restrict the unlimited ownership of apartments by any party, nor adhere to a 25% cap on rentals. Neither of these two issues were ever enforced. Robert?
According to current Florida law, when a restriction is in place and it is not uniformly enforced by the association for a period of time in excess of 1 year, that particular restriction is deemed to be waived by the association as to its enforceability. Under the circumstances as described, the specific restriction has not been enforced by the association, and as a result, to begin enforcing requires a process which is known as republication. Republication involves a written notification by the board to the membership that identifies the particular restriction that may not have been enforced through the years and an indication of a date at which point it will be enforced again. Existing violations under those circumstances will have to be allowed to remain. Ladies and gentlemen, I'll continue in a minute.
He's an attorney representing.
He's not a unit,
representing
Robert
his
Kay is
family.
not a unit owner either.
And Robert Kay's not a unit owner, right, okay?
So-
He's an attorney representing the man you're trying to
I want him removed,
Yeah.
and I want him removed.
Then
I'd
Robert
like
Kay has
you
to be
removed.
removed.
Okay? I'd like you removed, okay?
Ladies and gentlemen in the back, so it's clear.
Unit owner?
The board has the ability to invite whoever they choose to participate and attend at their meetings. The meetings are required to be open to unit owners. If anyone is not a unit owner and the board chooses not to allow them to participate or be in presence, then the board has that option. The fact that the board invited me to be here tonight and I'm not a unit
I did not invite
owner.
you, sir, and nor did
Nor
he.
was we
Well-
asked, how much money are you getting for this invite? We were not voted on.
You're not required to be unanimous in your decision making,
My
but
son's attorney.
sir, I don't know who you are. I assume
Power of
you're the attorney.
Introduce
The
himself.
power of attorney does not equal a unit owner for the purpose of attending a board meeting.
You're making
So,
statements.
sir, the board has asked that you leave, so I'm going to ask you to do so.
Stewart, calm.
Peacefully and quietly so we can continue with what we're doing.
Okay, well, with all due respect, I'm on the board as a steward, and I did not vote for you to be here. And you're welcome to be here, but I did not vote for it.
Well,
You're not a
that's
unit
not what
owner.
we're
Sir,
debating.
let me just speak. You're not a unit owner, and you are here. He's not a unit owner, and he is here. He's representing me, just like you're representing Scott.
No, I'm not representing
But
Scott.
I never voted on you to be here, and I have no
I'm
record of
engaged by the
Sir,
association
there's
as
no record of there
association
being a
counsel.
vote for you to be here.
This isn't
If you could
open for debate. The board has not requested this gentleman to be present. In fact, has
But the board
requested
has
him
not
to leave.
requested for you to be here, sir.
Actually, they did.
The board has not requested for you to be here.
My name's Jonathan Goldstein, I'm here to speak on his behalf now.
Jonathan, I'm going to ask you to not address the body and to please leave the meeting.
You're railroading this guy, and he can't represent, he can't be
This isn't the
represented.
forum for that representation.
Why
If he
isn't it?
feels
You're-
that
this
he's
is the
been
forum.
in
You're
any
going-
way legally wronged, he has remedies available to him.
Out of
I'll
his
leave that
pocket,
to
out
his
of his
attorney
pocket,
to explain
out
it
of
to
his
him.
pocket.
Sir, the unit
They're
owners
spending
paid
our
for-
money, they're spending our money for this,
For you to be
and you
here.
expect
I
him
never voted
to
for
take
you.
money out of his
Folks,
pocket.
you're interrupting the meeting at hand, so if you don't leave,
We're not
then
interrupting, we're trying to get equal representation.
that's
Haven't you
not
ever
what this
heard of
is,
equal
sir.
Why not?
This is a board meeting,
With all
and the
due
board is
respect,
But this is a
conducting
board
business.
meeting that you are interpreting, giving legal opinions to.
That's right.
And so
Because
it's a
I'm the
one-side, it's a one-sided deal. He's entitled to have a legal opinion.
It's not a courtroom, sir. This is a board
It's
meeting.
not a courtroom, it's a room in which you're railroading somebody and he
I'm
needs
not
to.
doing anything.
You
Scott
are, because
giving
you
an
have been
opinion.
asked to come here
Scott.
for a particular deed. Okay,
Scott
your
Samuels.
deed is to eliminate this
Scott.
guy from the board. He needs to have representation.
Not at this meeting.
Yes, well, if you're not going to get rid of him at this meeting, then that's true. But if you intend to get rid of him at this meeting, then that's not true.
Sir, the
He
basis-
He deserves.
Let me just address one thing. Sir, the basis for your removal of my attorney is that he's not a unit owner. You're not a unit owner and you're an attorney. So I'm just confused as to what your basis is.
The
It's
basis is,
inconsistent.
I'm invited, he is not.
Let me say, I'm sorry?
I'm invited, he is not.
On what, show me that you were invited. I need something to substantiate the fact that you
No,
were
you
invited.
don't. No.
Those are words
Out of
going
his
on.
pocket or out of my pocket. Here, these guys.
I did not vote for this,
Nothing
sir.
for you to
You know
handle.
what the rules
Sir,
are.
the unit owners are paying for you to be here and have a right to see something to substantiate that you were voted to be here by the board. I'm on the board, I did not vote for that, nor did Stewart vote for that. So on that basis, how is he removed? I'm not telling you to be removed. I applaud you being here, but why should my representation being here when you were not voted to be here? And if so, I'd like to see some proof of that, not your word.
I don't have proof to give to you.
So
at this
then it's
moment.
moot. Therefore, let me handle this. Therefore, my attorney should stay.
No, there is no if, then, or therefore.
Sir, you have a very weak argument. I have a right, sir, this is America, I have a right for my attorney to be here and defend myself.
You don't
I know you find that
understand your
cute.
rights.
I'm sorry?
You don't understand your rights.
Then why don't you teach me then?
I'm not here to teach you.
Okay, well,
You have an attorney.
Yes.
Let your attorney teach you.
you're just calling for his removal.
Well, he has no function at this meeting.
How do you,
I do.
these unit owners are,
I don't have to prove anything to you folks here tonight.
That's the law, Eddie. You're a lawyer.
Sir,
I am
I
aware of the
don't
law.
begrudge you being here whatsoever. The unit owners may because you're paying for him to be here. However, I have a right for my attorney to be here. Okay, Terry Tassini was here last week, who was not a unit owner. Why was he able to be here last week? This week he's 1% owner, which is fine. But that's a little inconsistent. Now I'm not allowed to have representation?
There is
Could
no
you clarify that,
requirement
sir?
for the board to be consistent as to who they invite to their meetings.
Really? Well, I'm a board member and a unit owner, and I'm inviting my attorney.
No, as a board member, one member of the board, you don't have the right to do that.
You just said I did.
No, the board as a body.
Okay,
That,
did the
that
body
requires
vote?
a majority.
I was not present for a vote for Terry to be here, and I welcome him being here, just like I welcome you being here. But there's no reason for my representation to be kicked out when I didn't vote for you to be here. There was no vote. 2 out of 9 people did not even participate in you being here. And you want to kick out my attorney?
At this point, I want to thank you for comments, and I'm going to continue with my presentation.
Okay. So I'm going to invite my attorney up here to...
No, actually, if your attorney doesn't choose to leave voluntarily, then he's going to be...
The association is aware, the association's attorney has been represented by counsel, the association's attorney wishes to continue speaking.
Speak up!
They can't hear
Good
you.
night, sir.
Robert, how about you get back to us in writing?
The association's attorney though does not have my consent to speak to my counsel.
Nothing in writing. In other words, you're a total dictator.
As I was saying before the interruption, the issue involved the lack of enforcement of a particular restriction for a period of time that the case law has determined to result in the inability of the association to enforce as to the particular restriction as well as any substantially similar restriction. The republication process that I described to you would allow for the resurrection of the enforcement of the restriction, but it requires the grandfathering in of those existing violations. In other words, it's not retroactive. We're not to be interrupted, ma'am, but the facts I've been given is that there hasn't been enforcement of the particular restriction for a period longer than 1 year. Well, that's the facts that I'm basing my opinion on.
That's not true.
I can't say it isn't. I only know what I've been given as a basis for my opinion.
I got a loud voice.
So based upon that, the opinion was given that the board would not be in a position to enforce without republication as to those particular owners that may have exceeded that particular number in your documents. That also does not allow the board to refuse future purchases without the republication that would violate that provision. Now the same holds true on, I'm sorry.
I said, what?
You'll have a chance to talk to the attorney. Let him finish what he has to say.
The same holds true on the issue of the percentage limitation on the number of units that may be rented at any one time. The facts I've been informed of is that the number exceeds the limitation in the documents and that it has been in existence for a period longer than the 1 year. As a result, the board is not in a position to limit the number of units that are being leased based upon the percentage restriction in the declaration without undertaking the republication process.
Okay, thank you, Robert. Now we'll move on to
Why
the,
can't we ask questions of
No.
what you just said?
no, you will ask questions when Mr. K finishes his last opinion, okay? And I'd appreciate if you don't speak out of order. And we're giving you the courtesy that you're going to be asking him questions. He's happy to answer them. And I'll call the person when they're ready. So please, a little decorum. We don't need more of this. The fourth item that Mr. K is going to give his opinion on is the restating of the 1995 rules regarding board meetings. We have had too many of these outbreaks at meetings by a few unit owners. And we have to stop it because we've got work to do that's very important here. And every meeting has been a ruckus. There'll be certain people, the same people, coming back, raising, arguing, fighting. We can't do that. We've got to do our business. We have important business to do. It is the board's intent to follow state laws and permit unit owners to speak at meetings. State laws allow associations to make reasonable rules for this process. IV's reasonable rules for unit owners' rights to speak at meetings were published in 1995, but not strictly followed. They are being restated here tonight in order for the board to conduct important board meetings without disruptions like we've had tonight and like we've had in the past few months. These rules will be followed. You will have a right to speak once on every agenda item for up to 3 minutes. The requirements for the meeting, according to the rules, in order to do so, you will sign up before the meeting starts for each agenda item. Since this is the first time, we'll waive that for tonight when we start our meeting, and when we have an agenda item, each unit owner can speak to up to 3 minutes on each item. But they can only speak once. There's not going to be any back and forth conversations. You can say whatever you want about the agenda item in that 3 minutes, and then you sit down, and that's the last time you're going to speak on that item. You want to speak on another item, you wait till that one comes up. We've got to get through these meetings. We can't have this rabble-rousing type of thing. Robert, you want to comment on the restating of those minutes?
The rules comply with the requirements that 718.112 subsection 2 set forth for the limitations that the board has relative to allowing unit owner participation at the board meetings. It is a requirement that unit owners be allowed to certainly attend and to participate and speak on agenda items. The rules that have evolved from that adoption of the statute in 1992 allows for a limitation of a reasonable period of time, which 3 minutes on each item has been determined to be reasonable, and a limitation on the number of times an individual may address a particular item, and also restricting giving your time to someone else. So that is an item.
You can't take the goddamn mic.
What?
Security. That constitutes.
You can't take the microphone.
Hold on. Security. That is assault. You need to call the police. That's assault. He did the same thing. I assault. That's threat. That's threat assaulted Scott. No.
I told him to take it and stick it.
Yeah, right? You have a temper worse than him. Never. I went after Scott twice. So you want a temper? How about the guy that said,